Started with our next panel, panel 4. So this one is called Rethinking Governance of the Marine Environment. And unfortunately, we are missing our final panelist, Tani Pryor. So just an FYI if you were waiting to hear from her. So the first panelist that we'll be hearing from is Professor Emeritus, David VanderZwaag. Again, Professor Emeritus of Law at the Schulich School of Law here at Dell, former Canada Research Chair Tier 1 in Ocean Law and Governance, as well as former Director and Associate Director of the Marine and Environmental Law Institute. So the title of the paper that we will be hearing is Governance and the Central Arctic Ocean, Cooperative Currents, Murky Waters. So without further ado.
Thank you, Sarah. So my topic is Central Arctic Ocean, and we have to rethink very soon because things are going to happen up there, and that's what my talk is about. To start out, we have retreating and thinning sea ice. It's placed the Central Arctic Ocean, a large donor hole in the high seas area and the underlying seabed on the political and public radar screens. Many models predict that we're going to see ice-free Central Arctic Ocean in late summer, around September, as early as 2050, maybe earlier. So we're losing the ice fast, including up there. And you get on the left panel, you'll see the pink line is where the ice was at the median in 1979 to 2000. And you see the white, that's where the ice was in September 2012. And we've been close around that since then. So the ice has really gone back. And then you've got the major potential shipping routes. We're all aware, I think, in Canada, the Northwest Passage, which is probably far down the line in terms of its commercial use in a big way. More importantly, of course, the Northeast Passage along the Russian Federation. And then you've got the green line over the top, the transpolar sea route. And again, there's now concerns that this be the shortest way from Asia to Europe, right over the top. And so again, shipping companies are starting to look in that direction as well. And of course, we had the famous Russian flag on the North Pole back in 2007, unleashed the media frenzy about the scramble for Arctic resources, including on the Central Arctic Ocean. We know there's not really a scramble. We do have not a wild frontier. We have a Law of the Sea Convention, etc. So that's where we are. So my presentation very quickly, I think I got a few extra minutes because we have one canceled person, but I'm going to still try to keep it around a little over 15 probably. Cooperative currents. We have global agreements and developments relevant to Central Arctic marine conservation, and then there are regional eddies, many regional arrangements and agreements, and then murky waters. And I wish I had more time. I wish I had an hour, because we really have to rethink long-range pollution. We have to think how we're addressing, under the Paris Agreement, climate change, because we're losing the ice, we're going to lose cultural ways of life of those living in the Arctic, so I won't have time to get into all of that. But I'm going to get some of the 4 uncertainties to be flagged. So a 2-part speed cruise, probably more like a moderate cruise because of time, that will follow. So I might skip over some PowerPoint slides. So 3 main global streams continue to flow. Obviously, we have the Law of the Sea as the overarching framework, and you have the UN Convention on Law of the Sea provides many guiding currents. I think most people in this room know about all this. We have the various freedoms that would apply to the Central Arctic Ocean: freedom of navigation, fishing, marine scientific research. Flag state jurisdiction prevailed as the primary control on ships up in the Central Arctic Ocean. You have various responsibilities on states to control activities of their vessels and nationals, including on the Central Arctic Ocean, generally protect preserve the marine environment, conserve high seas fish stocks, cooperate with other states if you're going to jointly manage those stocks at some point, undertake environmental EIAs, for plant activities may cause substantial pollution or significant add harmful changes to the marine environment. Take necessary measures to preserve and protect rare fragile ecosystems and habitat of threatened or endangered marine species. And of course, the Ant Loss Advisory Pin from May of last year noted that 194.1, where parties are required to basically prevent, reduce, control pollution of the marine environment. And they said, look, that also applies to greenhouse gas emissions. So all that there is in the convention. And of course, as we already learned from the other panel, coastal states have the right for extended continental shelf jurisdiction. And again, under the convention, control would go up to the International Seabed Authority, as Keith so well and others described this morning. Then you have the UN Agreement on Australian Highly Migratory Fish Stocks, often called the Fish Stocks Agreement, has various obligations potentially relevant to the Central Arctic Ocean, application precautionary and ecosystem approaches, and a commitment to establish a sub-regional or regional fisheries management organization arrangement where no such organization arrangement exists for a particular Australian or highly migratory fish stock. And then we have this new BB&J agreement. I'll come back to that towards the end of my talk. You have these now new cooperation currents out there undertaking, cooperating and exploiting marine genetic resource access and benefit sharing, MPAs and other various management tools, environmental impact assessment. I'll come back to that. And then you have numerous international maritime organization agreements and guidelines applicable to the Central Arctic Ocean. And again, we just spent a couple hours just talking about the IMO and how it applies to Arctic shipping. But the two main ones that really come central on focus are the Polar Shipping Code, came into force back in 2017. It sets out very strict pollution discharge standards in the Arctic, including the Central Arctic Ocean. You see the black line, that it does cover the whole Arctic, many national waters, but also Central Arctic Ocean. And it's basically a zero discharge for oily mixtures, discharges, noxious liquid substances, and there's all kinds of provisions trying to ensure maritime safety. For example, we now have global standards on ice-strengthened ships, ice-capable ships. Used to be, you didn't have global standards. And I could go on and on. I won't. What's under the Polar Shipping Code. And then you get a heavy fuel oil ban in Arctic waters coming into effect back in July of 2024. And it basically bans the carriage of heavy fuel oil as fuel up in the Arctic because if it gets spilled, it gets very hard to clean up in icy conditions. And there's some exceptions there, for example, for search and rescue and ships involved with pollution prevention and response, some exceptions. And then you get multilateral environmental agreements. I used to teach international environmental law. I could teach a whole course, but I can't. So I'm just going to say, the CBD, Convention on Biological Diversity, applicable to Arctic high seas in various ways. Each party required to cooperate with contracting parties to achieve and conservation stable use of biodiversity in areas beyond national jurisdiction, Article 5. And interestingly, the CBD Secretariat in 2014 helped to convene an Arctic regional workshop, facilitate description of what they call ecological or biologically significant areas, which identify two episodes in the Central Arctic Ocean, multi-year ice of the Central Arctic Ocean, and what they call the dynamic marginal ice zone in the Central Arctic Ocean, having open water periods in the summer. So again, under the convention, those aren't protected. It's up to states or through regional organizations or even global organizations to protect those, right? But at least it's been on the agenda now that, hey, the Central Arctic Ocean needs protection. And then regional cooperative eddies. So you have 3 regional treaties negotiated by the Arctic Council, a forum for consultation and discussion and study in the Arctic. They had task forces to apply, which came up with 3 regional agreements that they negotiated. Agreement on search and rescue in 2011. So we now know who's going to take the lead responsibility if a plane goes down or a ship has a problem up in the Arctic. We know which country is going to take lead, and the other countries can cooperate as needed. Have agreement on Arctic pollution preparedness response, again, applies to the high seas. And then you have also a 2017 agreement on enhanced international Arctic scientific cooperation. And you'll see the map there actually covers the Central Arctic Ocean and a lot of national land and territory as well, including marine areas. So again, there's call for cooperating on scientific data sharing. If you find things out about the high seas, try to share that data with the other parties under the treaty. And then you have regional cooperations by the Arctic 5 coastal states, often called the Arctic 5. Polar Bear Conservation Agreement, of course. I had to get a picture of a polar bear if you're going to go to the Arctic. So here it is. You have the 5 states having polar bears: Canada, Denmark, Greenland, Norway, Russia, and USA agree to protect polar bear dens and ecosystems, prohibit taking of polar bears except with a few exceptions: subsistence hunting, self-defense to save human life, and scientific purposes. And they get an action plan actually for polar bears adopted back in 2015, which again called for a greater study of climate change impacts on polar bears, for example. And then we get this broader Arctic 5+5 cooperation. Back basically in 2018, we get this treaty agreement to prevent unregulated high seas fisheries in the Central Arctic Ocean involving the Arctic 5 coastal states was China, Japan, South Korea, Iceland, and EU. And very quickly, the various commitments are to basically provide for a precautionary pause for at least 16 years, probably, to any commercial fishing until we have some kind of regional or sub-regional fisheries management organization set up and we have management measures in place. We need more scientific information as well. And they agreed to establish in 3 years enter into force conservation measures for exploratory fishing. And within 2 years, we need to develop a joint program of scientific research and monitoring and data sharing protocol. Committee meetings every 2 years, review agreement implementation, and consider whether if there are stocks there, should we move forward to actually establish a regional fisheries management organization or arrangement. That agreement entered force on 25 June 2021, and we've had now 3 in-person meetings and conference of the parties, all held in South Korea, and a joint program of scientific research monitoring framework and now an implementation plan have actually been adopted. An exploratory fishing protocol could not be agreed to at the June 24 meeting, and we're hoping now in next meeting in Norway in June 2025 to come up with an exploratory fishing protocol. So that's where we are. And then lastly, we have the application of the Northeast Atlantic Fisheries Commission and Convention. We have a Northeast Atlantic Fisheries. They actually have an area that goes right up into the Arctic. You see there the triangle on top. They have a whole Arctic region there. And they actually have adopted some conservation measures already. For example, on deep sea sharks, it prohibits directed fishing for deep sea sharks in that area, effective from February 2024 to the end of December 2027. And again, it requires future exploratory bottom fishing to undergo basically a scientific assessment process before we're allowed to go ahead up in that higher Arctic area. So murky waters. I think I may have 10 minutes left. So maybe a moderate 4, fast 4, quickly 4. One is sorting out the future Central Arctic Ocean fisheries governance arrangements. The fisheries agreement raises numerous implementation challenges. One is ensuring adequate financial, technical, and human resources. We all know that NOAA's been cut way back. Again, countries are facing problems with budgets. Let's develop, and the whole thing of biodiversity kind of taking second. So again, ensuring that is really not for sure. Developing process and timelines for scheduling vessels for a joint acquisition in the Central Arctic Ocean adjacent seas. Planning coordination among Arctic marine science programs. Even in Canada, science is really dispersed. Some out of governments, some of the universities. Universities even know what other universities are doing. It's really a real problem to pull it all together. And sorting out when commencement of negotiations for a new RFMO, Regional Fisheries Management Organization, arrangement might be appropriate. What constitutes adequate scientific information? The agreement, by the way, is actually quite indigenous and local communities friendly. It recognizes UNDRIP, UN Declaration of Rights of Indigenous Peoples. It calls for indigenous involvement in the scientific, including indigenous knowledge and local knowledge as well. So it's actually quite strong that way. But how is the precautionary approach to be applied? Again, it leaves it very wide open. There's going to be a strong precaution, weak precaution. And then fleshing out indigenous rights initiatives will be addressed. That's another big issue. Indigenous representatives have been involved in delegations to the meetings. So they've been involved, and they've been involved in the science and sharing knowledge. But again, down the line, what will their rights and interests, how that be addressed is really an open question. And then design on procedures to address future accession. Would Vietnam, would Philippines want to come in at some point? And they're going to look at that again soon and perhaps develop procedures for that. And tough question could be faced commercially viable fish stocks are eventually found. I don't want to be in the room where this comes up because it will be very, very controversial for sure. Should commercialization in the future be pursued even if commercially exploitable stocks are identified? One or more no-take areas might be actually benefit from favor by coastal states in case of straddling fish stocks. The sui generis, unique nature of the Central Arctic Ocean can justify a unique international protective response, conservation response. Be honest with you. If you're Canada, do you want China, South Korea ever fish off your EEZ? It's not been a good experience most places in the world, but then you go to the Arctic, what's going to happen there? And if commercial fishing should be allowed, what should be the access and allocation criteria? That is a huge issue if we have to face it. And for example, what about the Inuit? What about indigenous peoples? Should they have a priority? There's been no history of fishing, so most of the places where you look at historical distribution, things like that, here you don't have a history. How do you determine who in Asia, amongst the Asian states, gets the rights? It's a real potential problem. And then second, murky area, design future steps within the IMO to address the Central Arctic Ocean shipping. Arctic Council, as a projection of the Marine Environment Working Group, has taken a lead in considering future direction without specific decision or recommendations related to high seas fishing, high seas shipping. You had this report from 2014 undertaken under the auspices of Norway, which looked at the possibility maybe we could set up one or more particularly sensitive sea areas under IMO to protect either the whole area or particular pockets of the area, and we could have areas to be avoided, vessel routing, ship reporting, various possibilities there. So they focused on particularly sensitive area possibilities on the high seas. And then just in May, about a week ago, so we get this sent this report, Ecosystem Status, Human Impact, and Management Measures for the Central Arctic Ocean. It might be of interest to anyone concerned about the Arctic because it has a look at where we are with human uses, where it's likely to go. It has a Chapter 3 on governance and management measures of the Central Arctic Ocean. The problem with the report is that it's very descriptive. It is only allowed to really look at what's there. It could not really go forward and suggest prescriptions where we should go. I was actually a co-author of Chapter 3 and given strict instructions. Do not use your academic freedom to tell us where we should go. Particularly strong was U.S. Voice, who's one of the sponsors of this report. And so if you look at the report, they have findings, and then one of the findings is there that, yeah, we should probably look at maybe some other actions, perhaps looking at routing measures for shipping in the Central Arctic Ocean, addressing black carbon emissions in the Arctic, but it's a finding. So if you look at the Arctic Shipping Assessment in 2009, had recommendations, that negotiated recommendations. There's a follow-up through ministers. You don't see that here. This report's not been endorsed by ministers, by the way, because there was no ministerial declaration where he could do it, because they just had a meeting virtually on the Arctic Council back in May because of the Ukraine crisis, that they could not actually have a declaration. So again, this report remains to see where it goes. Third challenge and murky area is determining extended continental shelf boundaries in the Arctic and seabed development future. Only Norway has completed the Commission on Limited Continental process. It hasn't actually put its coordinates out there yet. Canada, Denmark, Greenland have basically filed their submissions with the Commission on Limited Continental Shelf. Russian Federation has gone through most of the hoops, but they're waiting to hear back from a subcommission on this Gackel Ridge. That is the big question in the Arctic seabed, because that would be the one area that could be a huge area beyond national jurisdiction. And the commission's going to come back next year and provide some further information. We'll see if it makes a decision or not, or recommendations or not. And then, of course, we have 2023 U.S. announced coordinates for Arctic extended continental shelf, but the legitimization issue looms there because it's not a part of the law of the sea convention. And the future then remains foggy, as I can see it, because will there be a mineral exploration and exploitation future or marine conservation future? And again, we see that debate globally. You're going to see it regionally as well. We've seen it in Norway coming up ready recently with their offshore. Again, they were ready to license, they pulled back. So again, this is going to be a very controversial area. And then finally, so I only have 1 minute and 35 seconds, how the new global agreement on BB&J will apply to the Central Arctic Ocean. When will it enter force? I checked this morning. As of this morning, we had 115 signatories, but only 21 parties. It takes 60 ratifications to get into force. And if you look at, what about Arctic states? 7 of the Arctic states, including Canada, US, have actually signed it. Russia has not, and none of the Arctic states have ratified. So what's its future? And then just a couple quick, I can't get into the details, but will the BGMA process be used to establish MPAs and other base measures be used to address regional protected areas in the Arctic, particularly the Central Arctic Ocean? Arctic may prefer instead to pursue protected areas to other avenues, sectoral avenues, protected shipping through the IMO, further fishing restrictions pursuant to the Central Arctic Ocean Fisheries Agreement, seabed mining controls beyond national through specific cooperation agreement or International Seabed Authority, and broader special area protection through a regional marine biodiversity conservation agreement or arrangement. So it remains to be seen how this will apply. And you'll see the agreement itself has constraints. Established MPAs and other area-based measures cannot include areas within national jurisdiction. So almost all the seabed is going to come under national jurisdiction, including the United States. So this will exclude most of the Central Arctic Ocean for protected seabed through an MPA. Conference parties must respect the continuities and not undermine basically relevant legal instruments and frameworks and relevant global, regional, and sub-regional sectoral bodies. So I'm going to wrap up. How will the EIA, environmental impact assessment provisions, apply to the Arctic? Watch out, because if you're a coastal state like Norway, and you eventually want to go out and develop your seabed, there's a provision in Article 28 where they could say, well, we'll just subject it to our national EIA process. It's very little international oversight, and you give information to other parties, but there's a very quite participatory process for other kind of proposals if it's not under national jurisdiction. So anyway, watch out for that one. And it's certainly how the EIA providers relate to the EIA obligation under other international schemes, like the International Seabed Authority. So is there EIA requirements going to apply, or is it under this, or they both apply? All that's open for question. And in conclusion, I'm wrapping up. I'm only about 30 seconds over. One final thought to capture where we are. It's a continuing voyage. We are now in a new world for the Arctic, and keep your eyes out. It's an unfinished voyage. What's the future of the Arctic Council, and might more formalized regional cooperation be possible, including the high seas? Is it possible? Arctic Council's been on pause, but if you look even at Canada's foreign policy statement from 2024, a new foreign policy statement on the Arctic, Canada says we're going to advocate for working within the Arctic Council to develop high seas MPAs and other effective conservation measures. So Canada's looking at the Arctic Council, maybe we come back to it. It's been having problems with the Ukraine war, but eventually we can move forward. And I can't get into all the details. There's other kind of bright lights indicate the Arctic Council could move forward. Because it's not clear how it's going to relate to the BB&J agreement and how you make that linkage once it comes into force. And then there's Trump administration. Yeah. Chief, you already gave the picture there. I'll just say this. The BB&J agreement was actually negotiated under the Biden administration. And now Trump, being America first, biodiversity second, I suspect we're going to have a real problem seeing ratification by the United States, at least during the Trump administration. So again, stay tuned. What will it mean, the Arctic Council? We don't really know for sure. We know that Greenland's in trouble, perhaps. Canada, well, we'll see where that goes. Stop there.
Thank you very much. I'll look forward to questions and having discussion about that a bit further. But next, we have Professor Dr. Sara Seck, who's the director of MELAW, and she was appointed as the Yogis and Keddy Chair in Human Rights Law in 2021. Since joining MELAW, her research has increasingly integrated attention to the marine environment, including at the climate-oceans nexus. So the paper that we will be listening to now is Relational Approaches to Business Responsibilities for the Marine Environment. Over to you.
Okay. So initially this panel was actually supposed to be Arctic focused, and then it shifted as one speaker dropped out. And I thought putting my panel paper here would be good because the third speaker was going to speak about gender in particular in the Arctic context. And she isn't, but nevertheless, I think we hopefully will have some thematic coherence here. I think what David has done is to although as you said, you couldn't do the deep dive into it, but even just sort of laying out the numbers and complexities of the kind of international agreements that are in place in a particular region points to, the extent of international law, and yet many problems remain. So what I'm going to do here is to share some thoughts about how the adoption of what I call a relational approach to legal analysis could inform the analysis of challenges and solutions to marine environmental problems, and in particular those that implicate business actors. And so I have picked two in particular to draw attention to at this point. First, the plastic pollution challenge is, as we know, a global one with implications for terrestrial and marine ecosystems, as well as human and planetary health, and more broadly. There are multiple UN Environment Assembly resolutions since 2017 that have called attention to the problem of marine litter and microplastics, culminating in 2022 with a resolution to end plastic pollution through the negotiation of a binding international treaty by 2024. And of course, negotiations are continuing this August in 2025. There are many other international environmental law regimes that address plastic pollution and the related chemical additives challenge in a patchwork and to differing degrees, from the Basel Convention to Stockholm to MARPOL. While the work of the Human Rights Council's Special Rapporteur on Toxic Substances has been particularly helpful in clarifying the human rights impacts of what is often described as the linear fossil fuel-derived take-make-waste plastic value chain. And I had the opportunity to work with UNEP and partners to develop training materials on a human rights-based approach to the plastic value chain for the Sea Circular project of the coordinating body of the Seas of East Asia a couple of years ago. And I will say that my team and I learned a tremendous amount during that process. Yet in practice, moving away from the plastics problem, even in Canada, is complex and frustrated by industry-led lawsuits and fossil fuel or petrochemical supporting provinces that challenge any federal attempts to regulate. The second challenge identified on this slide is whether, and if so, how to allow or encourage research, scaling up, and ultimately deployment of select marine carbon dioxide removal approaches as a climate mitigation solution, and perhaps for some, as a contribution to ocean restoration. And I note that this is a hot topic here at Dalhousie, with funds supporting largely, but not only, natural science research under the Transforming Climate Action Initiative of the Ocean Frontier Institute, with a primary focus on ocean alkalinity enhancement and macroalgae cultivation and sinking. And there are many different MCDR approaches. Classification is complex. Is it biological, chemical, physical, or other? And while there's generally widespread support for the idea of nature-based solutions, the line between nature-based and human intervention is not always clear, and many argue that despite the promise, nature-based solutions will not be enough, even if emissions decrease in line with the Paris Agreement temperature goals and net zero targets. What is clear is that international law is, as eloquently described in a recent paper by David VanderZwaag and MELAW LLM graduate Hafez Mohammed, a sketchy landscape with a foggy future. And so, in short, the patchwork of initiatives under the London Convention, the London Protocol, the Biodiversity Convention, and so on, combined with the development of carbon markets under the climate regime, have created a situation of uncertainty for scientists and researchers, while select eager venture capitalists and multinationals seeking to offset emissions through carbon credits are waiting, or not, in the wings, eagerly or not eagerly enough, depending on who you ask. And ironically, perhaps, the root cause of both the problems on this slide are essentially the same. Around 99% of virgin plastics are fossil fuel derived, and fossil fuel emissions are at the heart of the climate crisis, without which marine carbon dioxide removal would not be required. So clearly from both examples, international law solutions are crucially important. And I note as an aside that some countries have proposed a fossil fuel non-proliferation treaty as a response, and maybe that is a way to go. But as I will explain, I believe international law can deliver better if approached through a relational lens. So there's going to be a theory moment here. We've heard some reference to TWAIL. We haven't heard much. And we've heard some reference to Indigenous thinking. We haven't heard much about feminist approaches. So what is a relational approach to legal analysis and why is it necessary? My claim, and that of others, is that the problem is that the bounded autonomous individual of liberal thought plays a dominant yet unacknowledged role in everyday thinking and legal analysis. And this extends to international law, but is also prevalent in corporate law, environmental law, labor law, just law more generally. Why is it a problem? It's a problem because it isn't true. I'll explain that in a minute. But moreover, it inhibits the kind of legal analysis that is essential for local and global collective problem solving. And I think the only way to actually overcome it is to actively reimagine constructs and legal doctrines. And so this idea isn't something I came up with myself, but I was fortunate as a second-year law student at the University of Toronto to study feminist legal theory with Jennifer Nadelsky, who's written extensively about the concept of relational autonomy. And the work of others listed on the slide have contributed to my thinking. My claim is not that everyone understands a relational approach the same. In fact, you're seeing that idea in many, many disciplines and many ways of thinking now. But rather to relationally credit those whose work has been most influential for me, even as their work is built on that of others. And I note here several Indigenous scholars who've written about Indigenous ecological laws and gender, who's whether grounded in Nahiwa, or Anishinaabe, or Mi'kmaq laws, or others. So again, the insights that come from these are not all the same, but where I've gone in my work is to say that we need to actively replace the concept of the bounded autonomous individual with what I'm calling Desirai, the differentially situated, ecologically embedded relational individual, which is a handful, but all pieces of that are actually quite important. So while we, that is every individual, are differentially situated due to colonial histories, presence, lived experiences of discrimination and marginalization, we are all also ecologically embedded and socially relational individuals who are interdependent with and embedded in relationships with families, communities, local, transboundary, transnational, and global Earth systems. We can describe these as social and ecological relationships, talk about kin. We can talk temporally about the past, present, and future, and kinship relationships as with the more than human world. What's important is that the bounded autonomous individual pretends to exist and to live well all by themselves. But that, of course, is completely untrue. Nobody can realize their autonomy without being supported by social relationships that enable them and nurture them. And similarly, nobody can do the same without supporting ecological relationships. So what is required is a reimagining of the human. We spend a lot of time in human rights law thinking about the rights, and I would claim we need to think much more about the human. We need to think more about the state, how we understand the state, how we understand the corporate legal person, and I would point to the work of Lynn Stout in this capacity as an excellent example. And we need to think more about the worker, which the Special Rapporteur on Toxic Substances and Human Rights has done quite eloquently in thinking about how to protect the worker from toxins. I've got a big slide here that I'm not going to have time to go through on what thinking relationally about the state means, but I draw attention to the work of Karen Knopp in a brilliant paper from 1993 called Feminist Restatements on State Sovereignty. And the key pieces highlighted in bold are, yes, of course, the state is the dominant international legal actor, but when we foreground it, we should make no mistake that this can and does dilute cross-border non-state actor voices And these are important, and we know that through things like the UN Declaration on the Rights of Indigenous Peoples and others, but this should challenge how we even think about and understand what a customary international law norm is. A focus on the territorially bounded state, and I will note that Trump is the territorially bounded state on steroids, is problematic for many reasons, but one that it silences or pretends that it does not exist, the reality of interdependence, whether it's transnational economic interdependence or very clearly transboundary and global ecological interdependence. There are other bright lines that we should be cautious of. One, and I think we've heard, this isn't on the slide, but between ocean and land, there's a pretend bright line there that doesn't exist. Other bright lines between public and private actors, which can enable all kinds of issues in terms of states hiding behind sovereign walls when they're using their state-owned enterprises. Overall, just inhibits shared responsibility and also transnational corporate accountability, which is also a problem when there are bright lines between international and domestic laws, something that's very problematic in the Canadian context. And finally, a piece is to beware of assumptions about the unified states, because states are not uniform, and we know that very well in the Canadian context when we think of colonial histories and Indigenous rights. And so we need to promote acceptance of overlapping yet interdependent sovereignties, and this obviously includes Indigenous sovereignties, but polycentric governance. And I know I'm out of time, but I'm going to do then very quickly a set of slides. You'll see them in a flash. First, there is lots of evidence in international law of relational thinking, and I think in the oceans context there's quite a bit, and I think we're seeing some new movements that we could talk about at length. For the business and marine environment problems that I've put on the table, from the work that I've done, I see some possibilities. The Global Compact, the UN Global Compact gets a lot of flack, but I think the UN Global Compact plays a seriously important role, or could play a seriously important role, if business schools and law schools who advise corporate lawyers took it more seriously. It's an opportunity to teach and show businesses how to align with the United Nations principles, and the Sustainable Ocean Principles provide a lot of exciting potential. Not perfect, but being engaged, teaching and referencing them is very important. The work of the OECD and its guidelines for multinational enterprises, in particular the 2023 version, are also hugely important in this. An environmental human rights framework, I think, is also crucially important, and this is drawn from some work we had done before, brings in not just the substantive components, but also the procedural and attention to equity and non-discrimination. This is something we had produced for our work on plastics, human rights, and business responsibilities, centering circularity in product design, and again, thinking how to align global objectives with product design is actually crucial for addressing not just plastics, but also the climate crisis and the new MCDR technologies. It's helpful, encouraging to see that MCDR researchers are actually drawing on UN principles and UNDRIP and others as they develop guidance tools, and so that's a hopeful message. The OECD also has done some work with UNEP on responsible business climate action. And there's more that could be said about that. Remedy must be discussed for businesses. This is another image that we had developed from that project. And with that, I will close. Thank you.
Thank you very much to both of you. So I think we have about 5 or so minutes for questions. Does that sound good if we start lunch a little later? Well, first of all, do we have anyone online, if you have questions, feel free to send them in and we will navigate that. So we'll just change the camera around, I guess. But questions from the audience. And I'm told by Jordy that you can stay seated and just be sure to speak into the microphones. And, yeah. Anyways, questions.
People are hungry.
Yeah.
So David, you were talking about, and it kind of came up in my presentation as well, when you talk about an international environmental assessment versus the, under the state, like, when, again, talking, so I'll flip the question was asked to me, so I'll ask you, what would be better, like, again, using an international agreement for impact assessments under a BB&J that may or may not exist versus what, again, presumably the U.S. would have under that, or Canada has as an international assessment.
Yeah, if you go under the BB&J agreement, you have basically 4 on EIA. And again, you have to be a party to be bound by it. That's your first problem. But if you're a party, then if it comes into force, then it provides complex provisions on EIA. And essentially, to make it simple, if an activity is conducted under national jurisdiction and has significant impacts on areas beyond national jurisdiction, like the high seas or the area, then the country, a state, is given a choice: national EIA, or you go international. And the whole part lays out that international part. And it's very complicated if you go with the international part, because there's consultation requirements. It even has decision-making requirements, how you make your decisions. Eventually, it's to the party who has control and jurisdiction over the activity. If you go down the national route, there's very little oversight under the BB&J agreement. You just have to share your EIA reports, your information, and then the scientific and technical body, if they so desire, can make comments. That's it. So it's mostly national sovereignty over their own EIA. You can see why states who have extended continental shelves would probably want to look very closely at maybe the possibility of doing only a national EIA and avoid the very strict international consultation requirements. Again, this is open because there's language in it, you go the other way. They actually should do international, because it says if you undertake activities in waters beyond national jurisdiction, namely the high seas or the area. When you get into mining, the problem is it's both on the seafloor and above. And so it's kind of like you're in a twilight zone. Where do I go? And you probably should go international, but if you're a nation state, you probably want to go national and avoid all the headaches of going international consultation. I'm giving away a state secret here.
Other question.
I was going to say, unless the businesses that are operating are paying attention to responsible business conduct guidance tools that tell them that engagement, much more broadly, is vitally important, and that inform how they're conducting their business in light of broader international law principles. But of course, we don't teach that way as much as perhaps we should, so the business lawyers wouldn't know to advise their business clients about international law.
Just the other thing, I mean, EIA obviously is a customary international law principle now too. And so we have a lot of jurisdictional, cases from ICJ, it laws talking about that. So again, even the United States of America is going to have basic obligations under customary international law. I mean, they never really argued, I think, about EIA not being part of customary international law, part of the Law of the Sea Convention. So again, there's a whole customary international law part of this.
Aaron.
An excellent question. I will say that I've been using it I have been thinking about it mostly in terms of the human who is the holder of human rights, who then, if understood through a de Sera lens, would have responsibilities for reciprocal relations, kinship relations, including with nature and the more than human world. So not specifically in terms of standing of the more than human world through the rights of nature lens. But I admit that I haven't thought about that so much. It's been mostly the state, how to rethink the corporation, and Lynn Stout's work, again, is quite brilliant for that, how to rethink the worker, and the individual. But thank you for that question. I will keep thinking about that.
We just have a question from the folks joining us online. Thank you to both speakers for the insightful presentations. Professor VanderZwaag, regarding the 2025 synthesis report, based on your work, do you have any plans to publish an article consolidating insights that were considered but ultimately not included in Chapter 3 of the report, especially in terms of recommendations? Thank you.
That's a touchy issue, because I had co-authors, and we actually discussed that. And the problem you get into is you create a report, and you then have a difficulty going beyond it. So we haven't really resolved that issue. It's a good idea, though. There's an awful lot to be said. I will say there is an article that I wrote, and I should mention it if I can find it here. Basically, tinkering while the Arctic marine environment totters. Here it is. Tinkering while the Arctic marine environment totters, governance and this triple polar crisis. Just published in 2024 in Environment, Policy and Law, Volume 54. You want my critique of not just the Central Arctic Ocean, but the whole Arctic? It's there. And I'm really, really upset. I wrote an article 20 years ago on tinkering, and we're still tinkering on shipping, on all these areas. We're tinkering on climate change. We're not transforming. And when you get into pollution, long-range pollution, I've been calling for a global precautionary treaty for over 25 years of my life. And we're so far away from it. We're tinkering. We keep talking, hot air. So read that article. It's there. Now, maybe we should write a special article.
Maybe one more question if we have one. Yeah, Tata.
I just have a very short follow-up to Erin's question to Professor Seck. Would that imply invocation of critical post-human methods as well? When dealing with the beyond human?
And my answer would be, you will probably be able to tell us more about that than I can at this point. But yes, I've been watching your thinking and readings on that point, and that perhaps is where things need to go. What I love, I'll just say about this job, is you get to supervise brilliant people who go off and do and think about and read all these things that you really, really wish you had time for, but maybe also would never have dreamed up. And so that was a great question. Thanks.
All right, well, thanks, everyone. So I guess we'll break for lunch, and we're meeting back here. Are we still planning to do it's 1:45? Yes?
Yes.
Okay, so 1:45, let's go eat food and discuss more together informally.